To focus more on crime prevention and people who commit these crimes. There has to be a deterrent for them. It doesn't matter who it is. If it's a Canadian, there has to be a deterrent for this, unless we start really going back into the root of the problem, which is crime prevention, having youth not get involved in gangs and organized crime, and not get involved in the gun violence, and getting involved in the illegal drug trade. That's where I believe we need to focus. So I just wanted to get that point out before we moved on to another clause. Thank you, Chair.
Thank you, Mr. Morrison. I see Mr. Brock's hand up.
Thank you, Chair. Just following up on Mr. Morrison's comments, and I think I reiterated this several times in my interventions on Tuesday, but to this particular point, and this particular section number of the code is probably the most topical right now in our country. It has been topical for the last 10 years. It's what strikes at the heart of community concerns and safety. And I just worry about the message that this particular Parliament is sending to like-minded individuals who would be so cavalier with the lives of innocent victims as they carry out their vendettas on a gang by gang type of warfare. As I reiterated many times on Tuesday, they are very poor shooters. They shoot at random, quite often in moving vehicles, and innocent victims are impacted. To my colleague, Mr. Morrison's point, we need to send an appropriate deterrent message to the Department of Justice officials. I'm sure if I were to pose the question directly to them, they would agree with me that the primary sentencing features and focus of this type of offense is one of denunciation, it's one of deterrence, and it's removal from society. We already have a problem in terms of that messaging with mandatory minimum penalties already on the books. It's abundantly clear that these like-minded, violent, recidivist criminals absolutely have no regard for criminal law and the penalties that flow from it. And now, once this is heavily advertised that this is the new law, that Bill C-5 is actually making it easy for them to prey on each other and to impact communities, we are definitely going to see a spike in crime. And I certainly do not want to go on record as a former Crown attorney who fought daily to ensure my community was as safe as possible, that I fought daily to hold these recidivist criminals to account for their behavior. I certainly don't want my DNA on any part of Bill C-5 that supports this amendment. I will be voting against it. Thank you, Mr. Chair.
Thank you, Mr. Brock. Now I guess we'll go to vote for this. Sorry, who, Mr.
Sorry,
Moore?
Mr. Chair.
Oh, yes, Mr. Moore. Go ahead, Mr. Moore.
Thank you. I want to make one quick point because you had mentioned, Mr. Chair, that should Green 17 pass, then BQ1 would be would not be dealt with, or CPC 7. So I want to quickly remind, I even heard it today in question period, this idea, I believe it was the parliamentary secretary who did a great job, standing up and responding. But the only problem is I want to make sure we have the facts. And I don't want any member of the Justice Committee, because we should all be well informed on this legislation as well as the amendments, to be under any illusion of the origins of these of this particular provision. Section 244 sub 2B, mandatory minimum penalty of 4 years originally for discharging a firearm with intent, was introduced into our criminal code in 1995 under a Liberal government. And I don't know how many of you on the Liberal side know her, but Marlene Jennings, I believe she used to be the parliamentary secretary for justice. And when I was on the Justice Committee, she was on there as well, both in government and I believe in opposition. And Marlene is from the Montreal area, longtime Liberal. And I just want to quote her. She said, "It was a Liberal government that brought in mandatory minimum sentencing for firearm-related crimes. There is a whole category of them where currently it is a minimum of 1 year." Now, I'm not going to list off all those offenses because we've already dealt with a bunch of them in our clause by clause and eliminated the 1 year minimum. But she goes on to say there is a second category of designated offenses where currently it is 4 years. In committee, and again at report stage in the House, the Liberal members attempted to increase the 1 year to 2 years and the 4 year to 5 years. This was in May 17th, so just about this time in 2007. So for those of you that know Marlene, number one, she's certainly not a racist, because that term has been tossed around in the context of Bill C-5. You also know that she knows what she's talking about, and she was a longtime Liberal member of Parliament. So before we 10, I want it to be abundantly clear that the mandatory minimum that we are dealing with in this section has its origins in with a liberal government. So with that, I've finished with my comments, Mr. Chair.
Thank you, Mr. Moore. Seeing no hands up and nothing from the room, I'm going to put shall PV 17 carry recorded vote.
Mr. Ananda Sangari.
No.
Mr. Sorbara.
Je vote no.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Mr. Garrison, we couldn't hear you. I think you're on mute. We still can't hear you. We can see, and you're not on mute. It might be your.
It's a no.
It's a no.
Are you okay with that? Yeah. Okay, so maybe we should.
In the meantime, as audio can just figure that out.
Okay, it's a no, so it's 0 yeas and 11
0 yeas
nays.
and 11 nays.
Mr. Chair, if I may propose, I want to seek a unanimous consent on the matter.
Sure.
I would like to ask for unanimous consent to dispose of all the Green Party amendments from 18 through to 43 without consideration by committee.
Anybody oppose that out of the sitting members?
No.
No.
Nope. Just, we'll take the vote, but the clerk and analyst is just going to quickly look to make sure there's no effect on the subsequent votes in some of those cases. So if we can just hold for a minute or so. Thank you. I've been advised by the analyst that that's fine, so we will, those are all considered, I guess, deemed 0 to 11 as voted on. So, correct. So I will move forward. Next, we have block amendment 1.
Point of order, Mr. Chair.
Yes, Mr. Moore.
You had asked if there was unanimous. I thought the parliamentary secretary had asked for unanimous consent to deal with all of the green amendments at once, and I denied consent. So what, are we voting on something right now?
No.
Are we moving on to BQ1?
So my apologies. My understanding was there was silent. You just said that you. I might have misunderstood it. So I guess we do not have. You're saying we do not have unanimous consent. You want to vote by them one by one.
I do. I mean, I think we can deal with the vote on them quickly when they come up, because some of them are so profoundly ignorant. I don't think we should just lump them together and do away with them, because some of them would have an extremely profound impact on the safety, particularly of young Canadians. When you look at the number of clauses where the Green Party seeking to eliminate the mandatory minimum penalty, since they took the time to put these into our committee, I would like to take the time to vote against them and be on record as saying we need to do everything we can as parliamentarians to protect young people. So I don't know if you heard it, but I had unmuted and said no when you asked for unanimous consent.
Take that as a no, and so there's no unanimous consent. We'll go to
Point of order.
block amendment 1.
Point of order.
Yes. Mr. Moritz?
Just to be clear for the committee, the vote that you'd moved towards would have already been recorded under the UC that was proposed by the parliamentary secretary. From a Green Party point of view, we think we've been clear already at our last meeting with respect to the rationale behind judicial discretion, behind, as I've stated already, that mandatory minimum penalties do not deter crime. And so to this unanimous consent motion, these points have already been made in our view, and we would be very supportive of this committee moving them in one group, as has been recommended by the parliamentary secretary.
Thank you. Unfortunately, we'll have to go line by line as we do not have a unanimous consent, so we'll move on. Just looking at the screen. So we'll go to Block Amendment 1. It's page 25 of the package. Again, if the Block Amendment 1 is adopted, Conservative Amendment 7 cannot be moved as they amend the same line. Shall Block Amendment 1... would Mr. Fortin want to say anything on this, or are we good to vote?
En fait, Monsieur le Président, ce que je pourrais vous dire, c'est que cet amendement-là, c'est...
What I could say is that this amendment is a part of the reflection that we shared with the committee, with some members. We agree generally with the fact that the court should have the entire leeway to determine adequate sentences, take into account the maximum penalties stipulated by the law. But we would agree to eliminate the mandatory minimum sentences. For some crimes, it seems inappropriate, given what Mr. Moore or Mr. Morrison spoke earlier, the rise in violence in the past 1 or 2 years, especially in Montreal, but also elsewhere in Canada with firearms. We think that in the case of weapons violations, the most serious ones, that we should maintain them. Except that once, having said that, there's also the fact that we received a proposal by one of the witnesses, Professor Desrosiers from Laval University in Quebec. You'll remember him, who said, well, there's a compromise that might be acceptable, being to provide that the tribunal might make an exemption from mandatory minimum sentences in exceptional circumstances. Mr. Metier had also testified before our committee that saying that there are some circumstances where it seems inadequate to give a minimum sentence to someone who's shooting with a weapon into a cement wall to impress his friends. Well, he does deserve to have a sanction, but sending him in jail is not necessarily adequate. So we have to give the courts the possibility of making exceptions in exceptional circumstances. So we're proposing this amendment. We still have the minimum sentence, which communicates the population the severity with which we have to deal with such a crime. But we give the courts the possibility of making exemptions in exceptional circumstances. So the judge, before doing so, will have to explain why the circumstances of the situation are exceptional circumstances. And we believe that in that way, we will avoid situations where there are crimes that obviously should not lead to imprisonment, but we'll do that. But at the same time, we're sending a message to the population, not that the Parliament is being cavalier about the serious crimes that we're talking about. And so that's the justification for this proposal, which seems to be, to me, to be an honorable compromise between maintaining minimum sentences and giving the judges a possibility of making exceptions. Thank you.
Did you recognize me, Chair?
Yes, I did, Mr. Moore. Just waiting for you.
Thank you. Just a quick question to our witnesses. As I recall, the mandatory minimum penalty for this offense was 4 years. It was raised to 5 years for first offense. I think the amendment that the government is proposing would eliminate the mandatory minimum entirely. So I do see some merit in Mr. Fortin's amendment. Can you clarify to the committee that this would be reducing the minimum from 5 years to 4 years, but still maintaining a mandatory minimum? In fact, the mandatory minimum that existed previously.
As I understand the amendment, it would provide an escape clause for the 4-year mandatory minimum penalty, but not with respect to the 5 and the 7-year mandatory minimum penalty that exist, where a prohibited restricted firearm is used with a first offense, or where it's linked to organized crime.
Thank you.
Thank you, Mr. Morris. Seeing no other hands, I'm just going to double check with Mr. Garrison if he's able to hear what I'm saying, because I'm going to be calling a vote. If you can nod. Still can't hear you, Mr. Garrison, but... Okay. Would we be able to patch him in by phone at least?
He's indicating that he can hear you.
Okay.
But unfortunately, we can't hear him.
Okay, so I'll go to vote and we'll see thumbs up or thumbs down with him. So to block...
Mr. Chair, my hand is up.
Yes, Mr. Brock.
Thank you. I just want to highlight to the committee that this particular amendment, while I appreciate the spirit by which it has been brought forward, and I congratulate my colleague, Monsieur Fortin, for addressing the issue that's pertinent to our discussion, and that is the over-incarceration issue. But I also want to highlight that our conservative amendment number 11, it also speaks to the spirit of this particular amendment. And the only concern that I have as to why I cannot support it is that in criminal law, and particularly my previous career, I demanded clarity with respect to the law. And I guess an argument could be said that much of the litigation that flows from criminal law is a result of confusing terminology and different interpretations. So wherever possible, I look for clarity. I look for definitions of clauses. And the reason I cannot support Monsieur Fortin in this particular amendment is that what does exceptional circumstance mean? I don't know if that was contemplated by Monsieur Fortin, but it's certainly, I think the spirit behind it captures what we're trying to do. But this whole Bill C-5 was premised, again, at least some of the narrative of the government, to reduce litigation. And in my view, this creates more confusion. That's why I cannot support it. Thank you.
Thank you, Mr. Brock. Over to you, Monsieur Fortin.
Merci, Monsieur le Président. Je remercie Monsieur Brock.
Thank you, Mr. Chair. And I thank Mr. Brock for his intervention, and it allows me to complete my explanation on the issue of exceptional circumstances. I asked myself that question. I like law texts to be clear and that they don't provoke confusion. And I discussed with other jurists before proposing this amendment as stated. So the problem is that one cannot provide for all exceptional circumstances that might happen. By definition, if it's exceptional, it's not something common. But we want to show confidence in the courts, and I'm convinced that Mr. Brock would agree with me to say that judges are usually capable of making wise decisions and determine in particular cases what is exceptional and what isn't. I have confidence in the courts. in that matter. And I also have confidence in the appeal courts to reverse and amend decisions if there were an unjustified decision in such a case. But to try and define ahead of time in which circumstances judges would be allowed to waive this would be impossible. It's impossible to imagine all the circumstances. So it's done in many other cases. The same wording was used for exceptional circumstances. We should look at Professor Desrosiers's evidence. I think she had talked about New Zealand, if I remember clearly. Maybe it was Australia. But there are 2 or 3 other jurisdictions where that same expression was adopted, and it works well. And we have to let the courts do it. The judge has to explain what is the exceptional circumstances. If the judge does not do so, an appeal has to be brought. He must say what the exceptional circumstances are, how, in what way they are exceptional, and if the parties think that's been an error, then the appeal courts are there to correct the decision. Thank you, Mr. Chair.
I don't see Mr. Garrison on the screen. I don't know if he's, is he on the list? He's there? Oh, you're back, Mr. Garrison. Okay. Okay. I will, shall block Amendment 1 carry. Recorded vote.
Mr. Ananda Sangari. Mr. Sobara.
Je vote no.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison. No. You're good, okay. So it's 1 yea, 10 nays.
One yea, 10 nays. So it does not carry. Next, we'll go to Conservative Amendment 7. Mr. Moore, did you want to speak to it or anyone?
Just quickly, Mr. Chair, our amendment number 7 maintains a minimum sentence for discharging a firearm with intent to send a message that we don't tolerate drive-by shootings, that we don't want to have a revolving door of recidivism where the same individuals are committing serious crimes, getting out, and recommitting. So it would maintain a mandatory minimum of 2 years where the government is seeking to make the minimum 0 years of incarceration for discharging a firearm with criminal intent. Thank you, Chair.
Thank you, Mr. Moore. Shall Conservative Amendment 7 carry? Recorded.
Absolutely.
Mr. Ananda Sangari.
No.
Mr. Sobara.
Je vote no.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
Oui.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison. So we
That
have,
looked like a yes.
That was a no.
yeah. So we have 1, 2, 3, 4, 5, 4 yeas, 7 nays.
4 yeas and 7 nays. It does not carry. Shall Clause 10 carry? Recorded vote.
Mr. Ananda Sangari.
Yes.
Mr. Sobara.
Yes, please.
Mrs. Dillon,
Yes.
Mrs. Diab,
Oui.
Mr. Nagvi,
Yes.
Mr. Brock,
No.
Mr. Cooper,
No.
Mr. Moore,
No.
Mr. Morrison,
No.
Monsieur Fortin,
Non.
Mr. Garrison. So, say yes?
Yes.
So 6 yeas, 5 nays.
6 yeas and 5 nays. The clause 10 carries. Next, we have clause 11, and our first is a Green Party amendment 18 on page 27 of the package. Again, if Green Party amendment 18 is adopted, block amendment 2 and conservative amendment 8 cannot be moved as they amend the same line. So, hearing no questions on this, I think the Green Party member has said that he's already mentioned what he's had to say. I will say, shall Green Party amendment 18 carry?
No.
Okay. Recorded vote? On. Just do a recorded vote.
Mr. Ananda Sangari. No. Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison. So 0 yeas, 11 nays.
That's 0 yeas, 11 nays. It does not carry. Going over to block amendment 2, that's on page 28 of the package. Again, reminder, if block amendment 2 is adopted, conservative amendment 8 cannot be moved as they amend the same line. Monsieur Fortin, would you like to say anything on this?
Je pourrais.
I could speak, but it would be a like to filibustering because I would repeat basically the same things that I said earlier on Amendment BQ2. So again, it's simply a compromise. We're suggesting to maintain minimum sentences while allowing judges to waive them in exceptional circumstances. And here it's discharge of a firearm unintentionally.
No.
Mr. Ananda Sangari. No. Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi. No. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
No. Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison. No. So we have 1 yea, 10 nays.
We have 1 yea, 10 nays. It does not. Block amendment 2 does not carry. Next to conservative amendment 8 on page 29 of our package. Mr. Moore, would you like to say anything on this?
Well, for the same reasons stated earlier, this is an attempt to maintain mandatory penalty for this particular offense. The government's proposal is to eliminate it entirely. Our proposal would maintain a 2-year mandatory minimum. Thank you.
Thank you, Mr. Moore. Shall conservative amendment 8 carry?
Yes.
On division.
Recorded vote.
Mr. Ananda Sangari. No. Mr. Sobara.
Je vote no.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi. No. Mr. Brock.
Yes.
Mr. Cooper,
Yes.
Mr. Moore,
Yes.
Mr. Morrison,
Yes.
Monsieur Fortin,
Non.
Mr. Garrison. So we have four yeas, 7 nays.
That's 4 yeas, 7 nays. It does not carry. Now shall clause 11 carry? Recorded vote.
Mr. Ananda Sangari. Yes. Mr. Sobara.
Oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Oui.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison. Is it yes?
That was a yes.
So we have 1, 2, 3, 4, 6 yeas and 5 nays.
So that's 6 yeas and 5 nays. Clause 11 carries. Next, I've made rulings for Green Party amendments 19 to 29. They've all been deemed out of scope as they breach the Parent Act rule. So therefore, Green Party amendments PV 19 to 29, since they amend other codes of the Act, are deemed inadmissible. So I will rule those all to 29. We will now go to clause 12, all right? So we have Green Party Amendment 30, which is on page 41 of the package. Again, if PV 30 is adopted, Block Amendment 3 and Conservative Amendment 9 cannot be moved as they amend the same line. Shall Green Amendment 30 carry?
No.
On division, or?
On division?
No.
Is it so
No.
So it's carry on division? That's
It's carried on division. No, sorry. No, recorded vote then.
Sorry.
I'm getting used to this. Sorry, guys.
Mr. Ananda Sangari. No. Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi. No. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Mr. Fortin.
Non.
Mr. Garrison. It's no. So 0 yea, 11 nays.
0 yeas, 11 nays. Green Party Amendment 30 does not carry. Next, we have Block Amendment 3. Again, if Block Amendment 3 is adopted, Conservative Amendment 9 cannot be moved as they amend the same line. So shall Block Amendment 3 carry? Mr. Fortin, you're okay for me to proceed, or would you like to say something?
Écoutez, encore une fois, là.
Listen, here again, it's the same reasoning as for the two preceding ones, block amendments 1 and 2. So maintaining again the minimum sentence to really reflect the severity of the crime, but allowing the judge to waive it in exceptional circumstances. That seems most appropriate. This is a robbery with a firearm, so I think it's kind of strange to get rid of the mandatory minimum sentence in that kind of case. That's a strange message to send to gangs and the general population. We have to treat these crimes seriously, and we want to decrease shootings, not to decrease the severity of this, and to allow the courts to waive important sentences for these crimes. So we want to maintain the mandatory minimum sentence, but if there are exceptional circumstances, the court must again explain what these are before waiving them. Thank you, Mr. Chair.
10. Shall block Amendment 3 carry? Record.
Mr. Ananda Sangari. Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi. No. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison. So we have 1 yea, 10 nay.
We have 1 yea, 10 nays. The motion, the amendment does not carry. I'm just going to suspend for 5 minutes for Mr. Garrison. He's been advised by IT to just reboot his system, so we'll take a short suspension and resume back at 2:13. Resuming the meeting, I think we are now at. Where'd it go? CP, yes. We're at Conservative Amendment 9, page 43 of the package. Look at Mr. Moore or anybody. Mr. Moore, would you like to say anything on this, or shall we vote?
Thanks, Mr. Chair. Yes, for the same reason. I mean, this is one that, again, ripped from the headlines, robbery with a firearm. This would maintain a mandatory minimum. The mandatory minimum of 4 years is going to be eliminated entirely. So this would, in an effort to reach across the aisle and in a spirit of compromise, and as always, protecting our communities, it would maintain a 3-year mandatory minimum for robbery with a firearm. I think it sends the appropriate message, and I hope that all members will support this very reasonable amendment.
Thank you, Mr. Moore. So shall Conservative Amendment 9 carry? Recorded.
Mr. Ananda Sangari.
No.
Mr. Sobara.
Nope.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
So we have 4 yeas, 7 nays.
We have 4 yeas, 7 nays. It does not carry. Shall Clause 12 carry? Recorded vote.
Mr. Ananda Sangari.
Yes.
Mr. Sobara.
Oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
So we have 6 yeas, 5 nays.
We have 6 yeas, 5 nays. Clause 12 carries. Clause 13, we have Green Party Amendment 31 on page 44 of the package. Again, if Green Party Amendment 31 is adopted, Block Amendment 4 and Conservative Amendment 10 cannot be moved as they amend the same line. Shall Green Party Amendment 31 carry? Recorded vote.
Mr. Ananda Sangari. Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Mr. Fortin, we couldn't hear you.
Was it?
No.
No, okay. Mr. Garrison.
No.
So 0 yea, 11 nays.
0 yeas, 11 nays. It does not carry. Next to Block Amendment 4, page 45 of the package. Again, if Block Amendment 4 is adopted, Conservative Amendment 10 cannot be moved as they amend the same line. Monsieur Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Well, here again, it's the same as for the preceding amendments. Now it's the crime of extortion with a firearm. This seems to be a crime that's much too serious to abolish minimum sentences. That would send a very surprising message to the population who is worried about the increase of violence with firearms. So we're saying, oh, it's not so bad. We're even abolishing minimal sentences in those cases. So I don't want to engage in sensationalism, but I think it would be disastrous for the public peace. And so I think we should keep the minimal sentences and satisfy the objective of the government to allow the courts to waive these minimum sentences in exceptional circumstances, to the extent that one is able to show that there are exceptional circumstances in that case that would justify it. Otherwise, the minimum sentence would remain. Thank you, Mr. Chair.
Thank you, Monsieur Fortin. Shall block amendment 4 carry?
Mr. Ananda Sangari. No. Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi. No. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison.
No.
So we have 1 yea, 10 nays.
1 yea, 10 nays. Does not carry. Next, we have Conservative Amendment 10 on page 46 of the package. Shall Conservative Amendment 10, I should ask, is Mr. Moore or somebody wants to speak on that?
No, go ahead, Mr. Chair.
Okay. Shall Conservative Amendment 10 carry?
Mr. Ananda Sangari. No. Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
So we have 4 yeas, 7 nays.
4 yeas, 7 nays. It does not carry. Shall Clause 13 carry?
Mr. Ananda Sangari.
Yes.
Mr. Sobara.
Absolument, oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Yes.
Mr. Nagvi. Yes. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
No.
So we have 5 yeas, 6 nays.
We have 5 yeas, 6 nays. No what? So NDP didn't vote?
No, he voted. He voted against.
He voted? Okay. So we have 5 yeas, 6 nays. 13, Clause 13 does not carry.
Like to challenge the ruling of the chair, please.
It's not really.
Unfortunately, Mr. Anansinger, it's not a chair's decision, so it's a vote and to have a revote.
Mr. Chair,
Yes, Mr. Garrison.
suffering from continual technical problems, I thought you were calling a vote on section 13 as a whole?
I am calling Section 13 as a whole.
So I'm sorry, my vote was incorrect. I'm voting in favor of section 13, but I am still having continual technical problems here.
Okay, so let's just redo the vote. Is that okay? If I can, I'll do a recount on that vote, unless we just want to change Mr. Garrett's. I'll do a recount. We'll do it again if we can. Recorded vote on shall clause 13 carry.
Mr. Anand Asangari.
Yes.
Monsieur le Président, point d'ordre.
Mr. Chair, point of order.
Je pense
I think that in order to reconsider a vote that already took place, it takes the unanimous consent of the members. So if the members do not unanimously agree that we change the vote took place, it's in the record, and we should move to the next clause.
Mr. Anand Sangari?
Mr. Chair, I think it's
On the
clear
point.
that Mr. Garrison's been having some technical difficulties throughout the afternoon. I know we just recessed several minutes ago, and I think just given the hybrid format, I think it would be appropriate to give Mr. Garrison the opportunity to clarify.
Mr. Fortin, I'm going to make a ruling that we will do a vote again because Mr. Garrison was having technical difficulties. We had just suspended before. It is the will of the committee if they want to challenge me on that, but my decision stands that we'll redo the vote.
je respecte votre décision.
So I respect your decision, Mr. Chair. And with all due respect for your decision, it's not a technical issue that led Mr. Garrison to change his vote. He simply changed his mind because he voted. We saw him vote. We heard him. But I respect your decision, Mr. Chair.
Chair,
Yes, Mr. Garrison?
may I just say that the technical problems made it impossible for me to hear clearly which section you were calling, and I made a mistake in thinking which you were calling. I've been on the phone with IT. We've rebooted things. We've done everything we can. I apologize for the inconvenience to the committee. I'm not changing my vote. I voted incorrectly because I could not hear correctly what you called.
No problem. Thank you, Mr. Garrison. So we'll redo the vote for shall clause 13 carry recorded vote.
Mr. Anand Asangari.
Yes.
Mr. Sobara.
Absolument, oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison.
Yes.
6 yeas.
So we have 6 yeas, 5 nays. Clause 13 carries. Next, we have Green Party amendments 32 to 37. They all seek repeal of parent provisions. Since it is therefore the opinion that since they invoke on the Parent Act that they are inadmissible. So I'll be ruling Green Party amendments 32 to 37 inadmissible. We next have block amendment 5, which is on page 53, and I'm also making a ruling on that. It's
Give him a chance to move it.
the block would like to move block amendment 5.
Oui, Monsieur le Président.
Yes, Mr. Chair. So it's in the same spirit. I can hear myself. There's some reverb here. In the same spirit as the previous proposed amendments, Mr. Chair, we believe that minimum sentences harm the judiciary because it prevents the court considering exceptional circumstances in order to waive them. But we think that they're necessary in order to maintain a clear message for criminals, especially when we're talking about firearm violations with firearms. So we're suggesting this amendment, which was suggested to us. So we maintain minimal sentences, but we allow the judge who hears the case to invoke exceptional circumstances and have to explain why these are exceptional. Otherwise, he or she has to maintain the minimum sentences in the criminal code. So I think this is a acceptable compromise between the vision of those who want to maintain a hard line with minimum sentences and those who wish to soften that a bit. Thank you, Mr. Chair.
C5 amends the criminal code by repealing certain mandatory minimum penalties. The amendment block, Amendment 5, seeks to add a new section in the criminal code that would allow the court to waive any minimum punishment of imprisonment under exceptional circumstances. As House of Commons Procedures and Practice, 3rd edition states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, allowing the court to waive any minimum penalties in the criminal code goes beyond the scope of the bill. Therefore, I rule the amendment inadmissible.
Monsieur le Président, avec respect.
Mr. Chair, with all due respect, I would like to appeal your decision. I would like to ask the committee to reconsider it. And if you can you allow me to argument that point of order, please, Mr. Chair?
A challenge to the chair's decision?
Oui, Monsieur le Président.
Yes, Mr. Chair. That the chair's ruling be sustained.
Yes, to sustain, then this will be ruled out of order. Right.
Mr. Ananda-Sangarito.
Yes.
Mr. Sobara.
Oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Naqvi. Yes. Mr. Brock.
I'm sorry, Mr. Clerk, I did not hear the actual
The
question that was put to a vote. If that could be repeated, please.
that the chair's ruling be sustained. So if you vote
And
yes, you are in favor of the ruling. No.
And the ruling again was, I had some difficulty hearing.
Sure, Mr. Brock. The ruling was that the block amendment 5 is outside the scope of this bill and therefore inadmissible.
Thank you. My vote is yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
I vote to uphold the chair.
So it's 1 yea, 10 nays. Sorry, 10 yeas, 1 nay.
So the ruling sustains. It's 10 yeas and 1 nay. We'll go to Green Party Amendment 38, page 54 of your package. Similarly, I'm going to make a ruling that this is out of scope, and it's an opinion of the chair amending the principles of sentencing in the criminal code goes beyond the scope of the bill. Therefore, I rule the amendment inadmissible. Okay. Conservative Amendment 11 on page 55 of the scope of the package. I'm going to also rule that it's beyond the scope. It amends. Oh, sorry. I would ask that the Conservative, a member of the Conservative Party, move this motion, this amendment.
I am prepared to move the amendment.
Thank you. Bill C5 amends the criminal code by repealing certain mandatory minimum penalties. The amendment, Conservative Amendment 11, seeks to amend paragraphs 718.2e of the criminal code, which deals with principles of sentencing. As House of Commons Procedures and Practice, 3rd edition, states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, amending the principles of sentencing in the criminal code goes beyond the scope of the bill. Therefore, I rule the amendment inadmissible.
Mr. Chair,
Yes, Mr. Brock?
wish to appeal your ruling
Sure.
with argument?
There's no argument when you appeal a chair's decision. It just goes to vote. Mr. Clerk?
So that the chair's ruling be sustained, que la décision du président soit maintenue. So Mr. Ananda Sangari.
Mr. Clerk, just to confirm, so when we say yes, it will be to uphold the ruling of the chair.
Yes.
Yes.
Mr. Sobara.
Oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
So we have 6 yeas, 5 nays.
We have 6 yeas, 5 nays. The chair's decision carries. Next, we have Green Party Amendment 39 on page 56 of the package. Similarly, I've ruled this out of scope, and therefore I rule this amendment out of order. Next, we have Liberal Party Amendment 1.
Because Mr. Waters can submit if.
And I've Amendment 1. Nope, since nobody moved it, I guess I don't have to rule on it.
Monsieur le Président,
Mr. Chair, a Liberal motion? Are you telling us that... Oh, there's some reverb in my sound here.
Because it's from a member that's not a sitting member of this committee, it has to be moved in order to do. It came from MP Erskine-Smith, so.
donc vous me dites que les libéraux.
And so you're telling me that the Liberals are not supporting their own motion? Is that right? I don't think I'm understanding this.
Nobody in the room or a member of this committee is moving that forward, yes.
Alors moi je vais la proposer.
So I will move it then, Mr. Chair.
Liberal Amendment 1. I will deem it out of scope. It's in the opinion of the chair that allowing the court to impose a lesser punishment than any minimum punishment in the criminal code goes beyond the scope of the bill. Therefore, I rule the amendment inadmissible. Okay, and next we have Green Party Amendment 40 on page 58.
Point of order, Mr. Chair.
Yes, Mr. Garrison.
Sorry, I had trouble getting off mute there again. I think this question of members of other parties who aren't members of the committee submitting amendments should probably be dealt with. In my understanding of the motion that was passed in all committees is that independents are allowed to submit motions to committees and they will be deemed moved. I did not believe that members of other parties, just any member of parliament, could submit amendments to the committee. So I'd just like to know if that's not a correct interpretation of the rules of this committee.
I believe if independent, it's deemed moved. If it's not an independent, then someone has to move it. In this case, nobody from the Liberal Party moved it, but a member from the bloc that's on this committee did move it forward.
I understand the difference between deemed moved and moved. My question is whether our rules actually allow the submission by members of other parties who are not members of the committee. I did not believe that was the case.
My interpretation from our clerk is that any member of parliament can submit, but it would have to be moved by a member of this committee. So,
Or submit, if it's
or if he subbed in, he or she subbed in, then they're deemed a member at that time. Okay. Thank you, Mr. Garrison. We're going on to Green Party Amendment 40, again, page 58 of the package. The chair rules that this is out of scope. In the opinion of the chair, prohibition orders are a type of order not contemplated by Bill C-5 and therefore beyond the scope of the bill. Accordingly, I rule the amendment inadmissible. Now to clause. So now going to going to clause 14. We have Green Party Amendment 41. I believe Mr. Maurice would like to move that. No? Okay. We shall go to vote on shall Green Party Amendment 41 carry?
No.
No.
Recorded vote.
Mr. Ananda Sangari.
No.
Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison.
No.
So we have 1 yea, 10 nays.
We have 1 yea, 10 nays. It does not carry. Shall clause 14 carry? Recorded vote.
Mr. Ananda Sangari.
So, Clerk, just to confirm, so this is for the entire clause 14, and saying yes would mean voting in favor.
Yes.
Yes.
Mr. Sobara.
Je vote oui pour cette clause.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
6 yeas, 5 nays.
So that is 6 yeas, 5 nays. Clause 14 carries. Shall clause 15 carry? Recorded vote.
Mr. Ananda Sangari.
Yes.
Mr. Sobara.
Yes, please.
Mrs. Dillon.
Yes.
Mrs. Diab.
Yes.
Mr. Nagvi.
Yes.
Mr. Brock.
Absolutely not.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
6 yeas, 5 nays.
6 yeas and 5 nays. The motion, the clause 15 carries. Clause 16, we have Conservative Amendment 12. Mr. Moore, would you like to say anything on it?
Yeah, thank you, Mr. Chair. In many of our ridings, indeed across Canada, there's a serious crisis when it comes to drugs. Much has been said about Bill C-5, about so-called simple possession. Again, in the same vein as the mandatory minimums, the simple possession of drugs is not what is contemplated in this piece of legislation. In fact, it deals with importing, exporting, trafficking, production of Schedule 1 and Schedule 2 drugs. That includes heroin, cocaine, methamphetamine, etc. So these are A, serious drugs, B, serious crimes, and they have absolutely nothing to do with a simple possession. So what Bill C-5 does is it eliminates the mandatory minimum penalty for trafficking, importing, exporting, and distribution. And what our amendment does, CPC 12, is it maintains a 6-month mandatory minimum penalty for importing and exporting illegal substances, as has been the case with many of the conservative amendments. There's an attempt to bridge the divide between us and the government, who are seeking to eliminate many mandatory minimum penalties, and we feel there is a place for them when we're talking about taking drugs off our streets and going after the people that are causing this scourge in our society. So this would maintain a 6-month mandatory minimum for importing and exporting illegal substances.
Thank you. Mr. Morrison?
Yeah, just to maybe further a bit with Mr. Moore's conversation. Here again, talking in Parliament every day, not only we talk about gun offenses, but the other thing we're talking about is the opioid crisis and the drug crisis in Canada. At the same time, now we're talking about taking away mandatory minimum penalties for drug traffickers. That just flies in the face of us trying to get a handle on what's really the problem, which is prevention, people not using it. By giving people the drugs is not helping people to become recovered from using drugs. It certainly doesn't stop them from starting. And in this case, here's a prime example of a legislative change that is flying in the face of where we have a serious problem with the opioid crisis and drugs in Canada. Thank you, Mr. Chair.
Thank you, Mr. Morrison. Mr. Cooper.
Mr. Chair, to pick up on where Mr. Morrison left off, I can't think of a more ill-timed effort to repeal mandatory jail time for what are serious drug trafficking offenses with respect to Schedule 1 and Schedule 2 drugs at a time when we have an opioids crisis. Okay, I will restart then. Thank you, Mr. Chair, and I can't think of a worse time for this to be put forward, to repeal mandatory jail time for serious drug trafficking offenses involving Schedule 1 and Schedule 2 drugs. As Mr. Moore noted, that includes fentanyl and crystal meth at a time when we have an opioids crisis. 20 Canadians a day lose their lives due to an opioids overdose. And what this bill does is rewards those who push this poison onto our streets. This government talks a lot about helping those who are marginalized and vulnerable. They claimed that that's what this bill is, a big part of what this bill is about. In fact, this provision would do the opposite and should be defeated.
Thank you, Mr. Cooper. I think Mr. Brock has his hand up.
I do. Thank you, Mr. Chair. Continuing the discussion from my colleagues, I think the introduction of this aspect to Bill C5 just smacks of the liberal hypocrisy when it comes to the substantive issue. And the substantive issue is, and the elephant in the room, as my colleague Mr. Cooper has addressed, is the opiate crisis. Just did a quick Google search of the Liberal platform in the last general election. The opiate overdose epidemic has worsened during the COVID-19 pandemic. Tragically, in 2020, there were 6,214 opiate overdose deaths in Canada. To save lives, we need a whole of society approach to the opiate epidemic that addresses the main causes and supports who use drugs with the respect and dignity they deserve. That particular framework is not unlike the framework of the Conservative policy in the last election. Punish the trafficker, not the addicted. To that, I think we are consistent. And although that language isn't as clear as I just addressed, when the policy of the Liberal Party of Canada says to address the main causes, the addicted rely upon the traffickers. They rely upon the mules that are transporting the drugs across our porous borders. What kind of horrible message is the federal government sending to Canadians? The number one priority of a federal government, Mr. Chair, is to protect Canadians, not to continue to cause death. In my view, the Liberal government has blood on its hands because, quite frankly, they are talking a good game when it comes to the opiate crisis. There's very little mention in that in the current budget. They're not doing enough, Mr. Chair. And let's face facts here. How do traffickers conduct their business? They conduct it from the comfort of their own homes, Mr. Chair. And now this federal government with Bill C-5 is now giving license to the traffickers to serve the sentence in the very same place by which they do business. We've heard from several witnesses on this committee that conditional sentences do not work, notwithstanding the Liberal government narrative that it assists in their rehabilitation. Traffickers need to be punished. Importers, exporters, distributors of drugs need to be punished. They need to be removed from society, not to be given a legal license to ply their trade where they're conducting their trade before their arrest. Thank you, Mr. Chair.
Thank you, Mr. Brock. Shall Conservative Amendment 12 carry? Recorded vote.
Mr. Ananda Sangeri.
No.
Mr. Sobara.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Naqvi.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
4 yeas, 7 nays.
4 yeas, 7 nays. It does not carry. Shall Clause 16 carry? Recorded vote.
Mr. Ananda Sangeri.
Just to clarify, Mr. Clerk says 16, the entire clause, right? Okay. Yes.
Mr. Sobara.
Oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Yes.
Mr. Naqvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Mr. Fortin.
No.
Mr. Garrison.
Yes.
6 yeas, 5 nays.
That's 6 yeas, 5 nays. It carries. Clause 17. We have Conservative Amendment 13 on page 61 of the package. Mr. Moore, do you want to say anything on it?
Well, thank you, Mr. Chair. Again, just because we're onto a new clause, this is production of a substance. What are those substances include crystal meth, methamphetamine. Schedule 1 and Schedule 2 includes cocaine, heroin. I haven't heard any of this in the discussion that led by the government. What you will hear them say in the House of Commons, in their press conferences, is that this is about simple possession. That conjures up an image of somebody walking down the street with a joint. It does not conjure up an image of a trafficker outside of a school, of someone with a facility that's producing crystal meth, someone that is importing drugs across our border into Canada to devastate lives. And every day I think Mr. Brock mentioned he did a Google search. Like every day in our local newspapers, wherever you live, I live in a suburban area, whether you're rural, suburban, urban. Um, this is happening all over Canada. And I think it sends a terrible message that this parliament, certainly without the support of the Conservative Party, that this parliament would say, for production of a Schedule 1 or Schedule 2 drug, for importing and exporting and possession for the purposes of exporting, for trafficking, people know what that means. And I think that Canadians, when this comes out, and it will, I don't think everyone's busy in their day-to-day lives. They're very aware of the opioid crisis and other crises involving drugs in our community. But I think the more Canadians see of this, the more upsetting it's going to be, because these are the people that are preying on the children, all of our children. These are the people that are causing death, destruction, suicide, bankruptcy. We see it all over this country. And we're saying, if this passes, we're saying, you know what? If you produce methamphetamine, you're not possession of methamphetamine. If you produce it, if you produce crystal meth, you won't necessarily receive any time if you're convicted of that offense. That's what we're saying here. And I know most of you are probably aware of that. But I think it needs to be said. I think it needs to be very clear before we cast our vote that we're saying to our constituents that we think someone who's producing crystal meth, someone who takes that crystal meth and sells it outside of a school to children, we're saying as a parliament that person will not necessarily serve any jail time. There will be no mandatory minimum penalty that has existed for years within our Controlled Drugs and Substances Act. So we're all aware of it. I think this is very timely. In the same way gun crime is in the news every day, it's in the news because we're dealing with it. The opioid crisis is front and center. It's an absolute crisis causing devastation. And I don't think it's overstating it to say this is going to cause incredible damage when we send a message that we're going soft on traffickers, importers, exporters, and producers of crystal meth, methamphetamine, cocaine, heroin, etc. So I will certainly strongly be voting against this clause.
Thank you, Mr. Moore. Shall Conservative Amendment 13 carry? Recorded vote.
Mr. Ananda Sangari.
No.
Madame Brière.
Oh. Madame Brière, we cannot hear you. Madame Brière. Madame Brière, can you hear us? Madame Brière, can you hear us now?
Yes, can hear you now.
Okay, we're casting votes on Conservative Amendment 13. I'll have the clerk repeat the question and take her vote.
Well,
the question. I've already repeated the question. I'm just taking your vote.
Okay, no, it's okay.
Okay.
I vote no.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
4 yeas, 7 nays.
4 yeas, 7 nays. It does not carry. Shall Clause 17 carry? Recorded vote.
Mr. Ananda Sangari.
So this is again the entire clause 17. Yes.
Point of order.
Yes, Mr. Mort.
I'm just wondering if the parliamentary secretary is going to make that clarification before every clause that we vote on. I think we're all experienced parliamentarians here, so when you say we're voting on clause 17, it means we're voting on clause 17, and then when you say we're voting on clause 18, it means we're voting on clause 18. So I don't think we need that clarification before every vote.
Okay, thank you, Mr. Moore. He will go on to the vote.
Madame Brière. Madame Brière.
Yes.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock. Mr. Brock. I think we lost him. I think we lost him.
Mr. Brock, I think you taken your camera off instead of mute. If you can, we'll take the rest of the vote and
Mr.
hopefully
Cooper.
you'll get back on.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
Just missing Mr. Brock.
Mr. Brock? Mr. Brock, can you hear us? I don't know if he's on the.
Is he connected?
Yeah, he's there.
He's there. I'll give a few seconds. I don't know if.
Oh, he's back.
Oh, he's back. Mr. Brock, we're waiting for your vote. You're on mute, Mr. Brock.
I'm sorry, Mr. Chair, there was someone at my door. This is a vote on the clause as drafted in Bill C-5?
Correct.
Okay, my vote is no.
So we have 6 yeas, 5 nays.
We have 6 yeas, 5 nays. Clause 17 carries. Next, we have Clause 18. We have a Green Party Amendment 42. I'm going to have to rule this inadmissible as it's not, hold on, let me just tell you here. Since Section 9 of the Controlled Drugs and Substances Act is not being amended by Bill C-5, it is therefore the opinion of the Chair that the amendment is inadmissible. Shall Clause 18 carry?
Yes.
Mr. Ananda Sangay, sorry.
Yes.
Madame Brière.
Oui.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
So 6 yeas, 5 nays.
So 6 yeas, 5 nays. The Clause 18 carries. Shall Clause 19 carry? Recorded vote.
Mr. Ananda Sangay.
Yes.
Madame Brière.
Yes.
Mrs. Dillon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
So we have 6 yeas, 5 nays.
We have 6 yeas, 5 nays. Clause 19 carries. Next, we have Clause 20. We have Green Party Amendment 43. Note, if Green Party Amendment 43 is adopted, NDP Amendment 1 cannot be moved as Part C.1 of both amendments are identical. Shall Green Party...
Chair, can I speak briefly?
Sure. Yeah, absolutely.
Be very brief with the committee's time. This is a critical section of the bill. We are proposing an amendment that is similar to NDP 1 with respect to broadening the language, with respect to ensuring that this crisis is treated as the opioid crisis, as a public health and not a criminal one. And then additionally, recognizing in the diversion measures with respect to the fact that Black, Indigenous, and other racialized communities have been disproportionately affected by the criminal sanctions imposed in respect to the possession of drugs. Thank you.
Shall Green Party Amendment 43 carry?
No.
Mr. Anand Sangari.
No.
Madame Brière.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
So 1 yea, 10 nays.
That's 1 yea, 10 nays. The amendment does not carry. Next, we have NDP Amendment 1. Mr. Garrison?
Thank you very much, Mr. Chair. As you noted, the first part of the Green Amendment is identical since we use the same drafters as my amendment. The difference between the two was that the Green Party amendment that we previously defeated included some other things which I think arguably, fairly enough, may not belong in the principles. And so I understand that people voted against it for that reason. But I think what the Green Party and I agree on, and I think what all experts agree on, is that there are some people who are involved in the what we call trafficking of drugs, who are doing so only because of their own addiction, only to support their own habit, or only to obtain a safe supply of drugs for themselves. And so what I'm proposing here is that we add that narrow principle to the other principles in the bill to guide judges, so that we make sure that penalties aren't falling on people who are addicted, who are drug users, and are doing so only because of their own drug use habit. So I would ask members to consider supporting this more narrow amendment than the Green Amendment. Thank you.
Anand Sangari?
Yeah. Thank you, Mr. Chair, and just want to express that we are support in principle, but we feel that this is overly broad, and it could include high-level traffickers as well, so we will not be supporting this amendment.
Thank you, Mr. Nansangari. Shall NDP Amendment 1 carry?
Mr. Anand Sangari.
No.
Madame Brière.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
So we have 1 yea, 10 nays.
We have 1 yea, 10 nays. It does not carry. Next, we have Conservative Amendment 14, page 65 of the package. Mr. Moore?
Thank you, Mr. Chair. This was recommended to me by one of the provincial attorney generals. Their concern is under warning and referrals to remove the word consent to allow individuals to not be able to refuse to go for a referral to addictions treatment, but it would then allow them to refuse once they had the referral. So this is to make sure that individuals who are referred to addictions treatment and then consent to addictions treatment would not then be able to not get the help that they need.
Thank you, Mr. Moore. Mr. Garrison?
Thank you, Mr. Chair. I understand the sentiment behind this amendment, but I think in practice, where we have long waiting lists for referrals of people who actually do want to get into treatment, that it doesn't make much sense to hold up one of those spaces and on the waiting list, as exists almost everywhere, for someone who most surely is going to refuse if they weren't going to give consent. So I think in the real world, this actually just pushes people back from treatment who are ready and willing and able to get it. And we should, in fact, just recognize that people who won't consent to this will not consent to the treatment as well. So I think it's an impractical amendment in the real world of shortages of treatment spaces for those with addiction problems. Thank you.
Thank you, Mr. Garrison. Shall Conservative Amendment 14 carry?
Mr. Anandasangué. No. Madame Brière.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
So we have 4 yeas, 7 nays.
4 yeas, 7 nays. It does not carry. Next, we have NDP Amendment 2. This was given yesterday. I think all of you should have received it. It's page 66 of the package. I will ask Mr. Garrison to say a few words.
Thank you, Mr. Chair. There's actually no change in the amendments I submitted. It had been my intention to submit these two amendments separately, and I didn't give clear instructions, I guess, to the drafters, because the two things that were in the original NDP2 as submitted are quite different things. So the one we're voting on now asks that we amend Clause 20 by deleting lines 26 to 28. And what are in those lines? It's very easy. It says, subsequent charges not invalidated. The failure of a police officer to consider the options set out does not invalidate any subsequent charges laid against the individual for the offense. And so in reading that, I think I understand where it came from, but in fact, it undoes the whole purpose of this bill, in my view. In other words, it says, we want you as police to consider diversion, but if you don't, that's okay. Go ahead anyway, just like you always did. The charges can proceed. So to me, including this clause in the bill actually undoes everything else that we're laying out in the bill. And so that's why I'm proposing that we simply delete the clause that says subsequent charges are not invalidated if you didn't consider diversion, because in fact, we're trying to make sure diversion is considered. Thank you, Mr. Chair.
Garrison? Shall NDP, Mr. Anandasangué.
Thank you, Mr. Chair. So just wanted a little bit of clarification. So right now we have in NDP 2 we have A and B. Got it. Sorry.
We can circulate it if you wish. Okay. Mr. Cooper, do you have the one that was given yesterday? Okay, we can give you. Okay. And if you can give it over there as well. Shall NDP Amendment 2 carry? Recorded division?
Mr. Anandasangué. No. Madame Brière. Madame Brière.
No.
Mrs. Dillon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Mr. Fortin.
No.
Mr. Garrison.
Yes.
1 yea, 10 nays.
1 yea, 10 nays. The NDP Amendment 2 does not carry. Next, we have NDP Amendment 2.1. It was also given yesterday. It's page 66.1 of the package. If anyone needs a copy, Mr. Clerk will handed out. And I'll let Mr. Garrison, I just want to remind, sorry, if NDP 2.1 is adopted, then Green Party Amendment 44 and Liberal Party Amendment 2 cannot be moved as they amend the same line. So to you, Mr. Garrison, if you'd like to say something.
Thank you, Mr. Chair. Once again, this is simply the division of the original NDP2 into two separate parts, so that A was in the one we just previously defeated and B is in this one. So the concern that we heard quite often in this committee, and I've heard quite often in both of my previous time on the Public Safety Committee, is that in our criminal justice system, diversion is important. We have, discretion is important, and we have discretion for prosecutors and we have discretion for police that already exists, but we don't have any way to monitor how that discretion is used. And so one of the major purposes of Bill C-5 is to make sure that we're combating racial injustice and the disproportionate incarceration of Indigenous people, Black Canadians, other racialized people, and in fact, poor Canadians as well. Then we need some mechanism to find out how that discretion is being used. And so the bill as it stands doesn't require keeping records. And so my amendment says that records shall be kept so that we can use them for research purposes and for accountability purposes in seeing how the power or the discretionary power that police will have, which will be greatly increased here, is actually used, and make sure that discretion doesn't always go simply to the most privileged in our society. At the same time, there is always concern that if we're trying to divert people and we're creating a record, that this will somehow be used against people in the future. And so my amendment in the second part says that it does not, in fact, include any information which would identify individuals to whom the warnings or referrals actually relate, unless that information is necessary for public safety. So in other words, my intent there is, yes, you can use it in the case in which they were being diverted, because you need that for public safety to carry out the conditions, but no, you can't use it in future legal proceedings. And so that's why there are two pieces to this: requiring the police to keep records, and then allowing that those records can be used for research and accountability, but not in future court proceedings. Thank you, Mr. Chair.
Thank you, Mr. Garrison, Mr. Nansangari, and then Mr. Brock.
Thank you, Mr. Chair, and I would like to just confirm that we do support the amendment in principle, but we do believe that the language could be strengthened with some important safeguards that speaks to really what Mr. Garrison is intending to do here. So I don't know if you want me to read this out or if you rather table it for circulation to members, but it is quite, the amendment is quite extensive, and I believe, it is something that does cover the intent, but definitely put safeguards into place so that information cannot be abused and used in an improper way.
Sir, are you proposing an amendment to Mr. Garrison's amendment?
Yes, I am.
Okay. If you can give a hard copy and circulate it, and do you have it electronically or in printed format?
But for the virtual person, I will send it by email on their P9.
Yeah, so I think that Mr. Clark will be sending it forward to everyone. You have a copy of it, right? Or
I don't have a copy. I'll have it.
It's come to you right now.
Okay. In the meantime, should I go to Mr. Brock? Had his hand up. I guess he's gone. You got it?
I'm sending, but I need to send just. Yeah,
Okay.
I did, but
So the clerk will be emailing it out to everyone that's on virtually, and we'll give you, there's hard copies, they'll be coming to your P9s. hopefully everyone was able to have a quick read at it. So we will vote on the amendment, the sub-amendment first, and the same applies. So if the sub-amendment is...
Monsieur le Président, point d'ordre.
Mr. Chair, point of order. I've just received this, and I would like to have 5 minutes to read it. I received Amendment 2.1 earlier today, but it was simple. There were just 2 paragraphs. But now we have 2 pages of text. I didn't have time to read it, so I would need about 10 minutes to read this. Thank you, Mr. Chair.
Monsieur Fortin will suspend for, is 5 enough, or do you need 10 minutes?
Je dirais 10.
I would say 10 minutes, Mr. Chair. There are 2 pages of text. Thank you.
We'll return at 3:35.
Mr. Chair, just pointing out there's a typo in the last page there, the word individual. I'm sure that's not a big deal, but.
Thank you, Madam Diab. We'll suspend for 10 minutes. the meeting. We are going to be voting on the sub-amendment, the Liberal sub-amendment to NDP Amendment 2.1.
Point of order.
Yes, Mr. Moore?
Mr. Chair, it's a Friday heading into the long weekend. This meeting is scheduled to go from 1 to 3, your time. It's currently 4 o'clock, so we're an hour over. There was no motion to extend the meeting. I think we've all been operating in good faith, but now we're seeing amendments. I remember the clerk asking for amendments through you, Chair. You asked for amendments like last week, to which we provided, the Conservative Party. Now we're seeing amendments that have just been recently tabled, and we're continuing to see amendments. So if I thought there was a chance it would pass, I would move a motion to adjourn, but I suspect the NDP would support the Liberals in keeping this meeting going into the evening as they did last time. But I'm just a little concerned as, how many more of these amendments are we going to see when, to do this job properly, as I think Mr. Fortin had said, we need to see these amendments. We need to study these amendments. We don't drop amendments unless it's an emergency. We don't drop amendments as we're dealing with the, with that clause. I mean, that's just asking for delays. And this meeting has already been delayed over an hour. I fear that we're going to have more unnecessary delays if we continue to table drop what are technical amendments that have an impact that has not in any way, shape, or form been explained to us. So I'd ask for an explanation of these amendments and sub-amendments, and then, an undertaking that in the future, when we have government legislation, remember, this is government legislation, and now we're talking about government amendments. So, we need to get them in on time.
Thank you, Mr. Chair. And look, I want to thank Mr. Moore as well. These are amendments that were put forward by the different parties, including amendments that are put forward by the Conservative Party. As a government, we've reviewed them extensively, and I think from the outset we've said we would engage and we would make sure that we accommodate and strengthen the bill as much as possible within the framework of the committee process. And the sub-amendments that we've provided, and I do want to just speak to the one with respect to Mr. Garrison. It stems from the amendment that was already tabled by Mr. Garrison, and we feel that the wording that we've provided strengthens the amendment and strengthens the bill overall. And like Mr. Moore, I know that they have an amendment there that we want to work with him on supporting as well. So it does work on all three opposition parties that are represented here, and we're working in good faith to really strengthen the bill and have this move forward. Having said that, if Mr. Moore wants additional information on the amendment provided, I can speak to it, but I do think at the outset I indicated that we, in principle, support the intention brought forward by Mr. Garrison in his amendment, his NDP 2.1, and we have just added language that I believe provides some safeguards on the record keeping, that provides some transparency, as well as ensuring that the information that's gathered is not used in an adverse way to the individuals. So I think it's paramount that we are driven by data. And just to your point, Mr. Moore, and I know the Conservative amendment that will be forthcoming on review, I believe data is so critical to that kind of a review that's going to that's likely to take place. So I think it is in that spirit that we brought this forward, and I believe even the other ones we forwarded, and I'll speak to them separately, is with the intention of strengthening the bill.
Thank you, Mr. Nansingari. Mr. Fortin, and then Mr. Garrison.
Merci, Monsieur le Président.
Thank you, Mr. Chair.
Ça va? Vous m'entendez?
Can you hear me?
OK. Alors, Monsieur le Président.
So, Mr. Chair, I agree with what Mr. Moore said, namely because we received the amendment to 2.1 just a few minutes ago. We looked at it a few moments ago. Then we received the amendment very shortly after. But it probably was available since this morning or even for a few days. Therefore, I am somewhat shocked to be receiving this at the last minute, and it is really not conducive to our work. I also think that if we want to work properly, with due respect to democracy and to all individuals around the table, that we should come back to these matters after the break week. I'm sure Mr. Garrison and the Liberals will object and that we will prolong this committee, and I don't know for how long, but I do deplore this situation. And I would like to observe that it is quite difficult to work in these circumstances that the Liberals and the NDP are imposing on us, or should I call them the new Liberal Democratic Party. With that said, Mr. Chair, if we must continue, I will have questions for the two witnesses joining us today. I would like for them to elucidate me on certain aspects of the motion.
Thank you, Mr. Fortin. Mr. Garrison?
Thank you very much, Mr. Chair. And I do want to point out that the subject matter 2.1 was in the original package of amendments. 2 and 2.1 were simply separated to allow us to vote separately on the two parts. So this subject matter has always been in the package of amendments. Having said that, I have had a chance to, like everyone, look at the wording of the sub-amendment. I've been a member of Parliament for quite a while. It's quite normal for sub-amendments to come up in the discussions of bills without much notice, especially if we're trying to work collaboratively to improve bills. And so I've had a look at the proposed Liberal changes. I think they respect the principle of what I was trying to accomplish. I just didn't have a staff of lawyers to do the drafting on my team that obviously are available to some of the other members. So I'm very much in support of the sub-amendments. I think they still do the same thing that we were trying to do, and that's making sure we can have accountability on the use of discretion without endangering that those who get diversions might have that used against them in future legal proceedings. And I think the wording the government has worked out accomplishes that much more eloquently and much more carefully than my original wording did. So I'm in support of the sub-amendment. Thank you.
Thank you, Mr. Garrison. Just to reiterate, I think all the amendments were, I want to thank all the parties for giving them well in advance and have a pretty robust package here of amendments in a good order. And I think Mr. Garrison amended his amendment into breaking them into two parts. And Mr. Fortin, the clerk, has assured me they were circulated to all members of the committee yesterday. So the NDP 2 and the NDP 2.1 were circulated yesterday. I think in the Liberal sub-amendment to 2.1 was done just now, which you did receive. So as Mr. Garrison also stated, that it does happen in committees where in the process there are amendments that can come from the floor, and they were presented, and we, at your request, also suspended so that we could look at those. So I think they're all in order. But just to let Mr. Moore know on his point of order, I don't foresee any others that are at least given to me ahead. So this would be the last one that I know of, unless something else comes up that I'm not aware of. I cannot answer to that, and it's the will of the committee to bring anything up. But as far as I know, I think these were the only two that were brought in, and they were circulated yesterday. So I think Mr.
Chair, if I may
just, Mr. Nansegari,
just confirm, there are a couple of more that we've already sent to the opposition parties.
Okay. Well, there you go. So there's some sub-amendments that two more that have been circulated to you. So I'll let you look at that. Mr. Brock, is this another point of order, or?
It is, Mr. Chair. Can you provide some explanation why there was no motion to extend?
It seemed to be the will of the committee that to keep going, and there's only motions to adjourn. There's no motions to.
That's completely incorrect, Mr. Chair. With all due respect, I think you owe it to every committee member to respect our outside commitments. This meeting was scheduled for 2 hours. There was no discussion this past Tuesday that we would extend indefinitely, and I think procedure must be maintained. There is a procedure for motion to extend, and I'm rather disappointed that you as chair did not raise that at 3 o'clock. Thank you.
Thank you, Mr. Brock, but unless you have a motion to adjourn, I will continue to proceed. I think next we had Mr. Fortin, who wanted to have, before we cast a vote, a question to the witnesses.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Yes, when I read the sub-amendment to NDP 2.1, but sub-amended by the Liberal Party's proposal, here's what I understand. And I believe our two witnesses will have read the text. Otherwise, I will wait until I ask my question. Can we continue? Have they read it? We have read it. Thank you. So here's what I understand when I read this text. The diversion measures that would be applied or designated for an offender would be recorded in the file by the police force in question. But the name of the offender would only be known by the judge presiding over the case on the offense in question. However, if beforehand the offender has committed other offenses and is a recidivist, whether or not that individual had respected the diversion measures, could this or not be presented at the court? Could it be said before the court, listen, we tried to include this individual in a diversion process. We tried 3 or 4 times, and this individual, this offender, did not respect the measures or did respect the measures but still reoffended. Is that true that we could not say that before a court? We could not claim that recidivism by the same individual was, even if it were up to 20 times, that we could argue before the court that we had used diversion measures. Am I understanding that correctly?
Understand the amendment, it only relates to records that are kept in relation to warnings and not offenses. So where the police officer issues a warning or makes a referral to treatment program, the uses that would be permitted would be limited to where to proceedings with respect to the offense to which the record relates. So if, for instance, a police officer makes a warning or a referral in one case, and that person doesn't successfully complete that treatment program, that warning or referral would not be able to be used in an additional case afterwards, only with respect to the offense for which the warning relates.
Donc, même si...
Okay. So even if the person has reoffended 5 or 6 times, it can never be mentioned at the court.
Just to clarify, when you mean, quand vous parlez de récidive...
When you talk about recidivism, you are talking about when a person is referred or warned and has to be referred or warned another time? Mr. Fortin says. Oh, I'm hearing some reverb. Yes, the person is in a diversion program. So what I want to ensure that I'm understanding about the motion here is at 10.42a, it is said that it can be mentioned to the judge or court for any purpose relating to proceedings with respect to the offense to which the record relates. So the offense to which the record relates in my mind, for example, on such and such a date, this was the offense. And then if the individual repeats the same infraction 3, 5, 10 times afterwards, and if that individual does or does not follow the instructions given by the police, would we then still not be able to say to the court, listen, it's been 3 times, we've tried everything with this individual, whether it be treatment or therapy or whatnot, this individual is not following therapy and has committed the same offense again. And I know that they have not been convicted another time, but they are repeating the offense. So is it true that that cannot be mentioned to the judge?
To the extent that the person was warned and later on needed to be warned again or referred again, paragraph A would limit the record of that warning to the initial proceedings where the person was warned. There are other paragraphs that would permit the uses of those records, like for instance, paragraph B. The record could be released to a police officer for any purpose related to the administration of the case, but again would be limited to the record. Would be limited to which the record relates. If you go a little bit further under subparagraph 2. There would be the record would be able to be used, for instance, in a pre-sentencing report, but again would be limited to in respect of the offense to which the record relates.
Merci.
Thank you.
Thank you, Monsieur Fortin. We will now go to a vote on shall NDP Amendment 2.1 Liberal sub-amendment to the NDP Amendment 2.1 carry. Recorded vote.
Mr. Ananda Sangari.
Yes.
Madame Brière.
Oui.
Mr. Sorbara.
Yes, please.
Mrs. Diab.
Oui.
Mr. Nagvi. Yes. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
6 yeas, 5 nays.
6 yeas, 5 nays. The sub-amendment carries. Now shall NDP Amendment 2.1 as amended carry. And before that, I just want to remind, if NDP 2.1 as amended is adopted, Green Party Amendment 44 and Liberal Party Amendment 2 cannot be moved as they amend the same line. So shall NDP Amendment 2.1 as amended carry?
Mr. Ananda Sangari.
Yes.
Madame Brière.
Yes.
Mr. Sorbara.
Yes, please.
Mrs. Diab.
Oui.
Mr. Nagvi. Yes. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
No.
Mr. Garrison.
Yes.
Carried 6 yeas, 5 nays.
Carried 6 yeas, 5 nays. We now go to NDP Amendment 3. Mr. Garrison, would you like to say anything on this?
Yes, thank you, Mr. Chair. The bill C5 addresses the problem of over-incarceration of Indigenous people, Black Canadians, other racialized Canadians, in some modest steps, I would say. But over-incarceration carries with it another obstacle for those who have been incarcerated for reconnection with their community, with their family, with employment, with housing. And that's because once you've been incarcerated, of course, you come out also with a criminal record. And so criminal records quite often have large effects on child custody cases, on access to social housing, access to any housing, as landlords quite often insist on criminal record checks. And perhaps most importantly, criminal records can make it very difficult to get reemployed. So all of those things make it hard for those who've already been incarcerated to reform and get back in contact with their community. So what this amendment essentially proposes is an automatic removal of all criminal records for personal possession of drugs that have taken place in the past, and this would take place within 2 years. The second thing it does is it ensures that future records for convictions for personal convictions that result in a record, but that record would be removed 2 years after completion of the sentence. And it does so without specifying or without requiring, I guess I would say, an application process. We all know that application processes for pardons or suspension of records, as they're called, are quite often very difficult to get, quite often very expensive. But even more importantly, lots of times people don't even know that they need to have a criminal record removed. Landlords certainly don't phone people back and say, oh, by the way, you didn't get the place because you have a criminal record. And employers quite rarely say, well, I chose someone else because you have a criminal record. So people may not even be aware of the ways in which they're being disadvantaged by criminal records. Remember, this is only for personal possession of drugs, not for trafficking, not for offenses involving violence. So this would remove those records. There's other things I personally would rather see, and we know that Bill C-216, a private member's bill calling for the decriminalization of all personal possession of drugs, had its second hour of debate in the House today. We don't know the fate of that bill. We'll be voting on that as the House as a whole when we come back. But what we have today is an opportunity to do something more than just reduce the mandatory minimum penalties. And that is to contribute to the reintegration and rehabilitation of people who've been imprisoned for personal possession by making sure that those criminal records don't affect their families, don't affect their housing, don't affect their employment. And so I'm urging members to support this amendment that takes this bill a little bit farther in attempting to repair the damage from the over-incarceration that Indigenous people, Black Canadians, other racialized Canadians, and many poor Canadians have already suffered as a result of incarceration for personal possession of drugs. So the bill reduces mandatory minimums. This would take away some of the stigma that goes along with that by removing those criminal records. Thank you.
Thank you, Mr. Garrison. Mr. Fortin?
Oui, merci, Monsieur.
Thank you, Mr. Chair. I understand the intention behind Mr. Garrison's motion. And in many respects, I agree with him. But I do have certain reservations about rewriting the history. I don't quite see how we can say that this did not happen. It did happen. Perhaps it shouldn't have happened. Perhaps we could wish that it hadn't occurred, but it did. Today, we don't hang people anymore if they've murdered someone, but we didn't decide to resuscitate the people who were murdered when we decided no longer to hang the person who killed them. So, Mr. Chair, what I'm having trouble with is the suggestion that we should eliminate or hide the prior conviction.
Thank you, Mr. Fortin.
Si on peut le faire.
To Mr. Nansingari.
Thank you, Mr. Chair, and I want to propose a sub-amendment, and I think that's been shared with the members. I echo fully what Mr. Garrison has indicated with respect to simple possession. It is something that I know we want to support Canadians who may have been impacted by charges or convictions of that sort. I think it's important to allow for pathway in order for people, many of them who are young, to be able to continue their life without a serious interruption, whether it be with respect to jobs, even engagement within the community or any other place where a criminal record check is required. We've just changed the language slightly. It does not in any way change the intent or substance of the amendment that's put forward by Mr. Garrison. So we hope members can support this. It is it's a small step, and I believe it's a modest step towards supporting those who've had primarily addictions and who have had possession charges in their lives.
Thank you. So we have a Liberal sub-amendment to NDP Amendment 3 that has been circulated. Let's, shall Liberal, the Liberal sub-amendment to NDP Amendment 3 carry? Recorded vote.
Mr. Ananda Sangari.
Yes.
Madame Brière.
Oui.
Mr. Sorbara.
Oui.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison.
Yes.
Yea, 6, 5 nays.
We have 6 yeas, 5 nays. The NDP, so the Liberal sub-amendment carries. Now shall we vote for the NDP sub-amendment, so NDP Amendment 3 as amended, carry. Recorded vote.
Ananda Sangari.
Yes.
Madame Brière.
Carry. Yes.
Mr. Sorbara.
Yes, please.
Mrs. Diab.
Yes.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison.
Yes, thank you.
So yeas, 6, nays, 5.
Yeas 6, 5 nays. The NDP amendment as amended carries. We have next we have the block amendment 6, page 70 of our package. Monsieur Fortin, would you like to say a few things?
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. Chair. Well, when we heard from witnesses, Dr. Robert testified that there was a problem with those people working in the field with people suffering from addictions. And what was observed, that these people are found in possession of small quantities of drugs. And these individuals who work in the field have no choice but to handle those drugs. And the individuals who possess them say to the worker, the social worker in the field, please take this bag of cocaine because if I hold on to it, I know I'm going to use it. And then the social worker or whoever the worker in the field is brings it to someone who can dispose of it properly in a legal manner. But these individuals working in the field could have reservations to taking that substance because they might be found in violation of the law. So these service providers in communities, as part of their duties, and we know that they're not going to use it to have fun on the weekend, they should legally be allowed to be in possession of a substance, and this shouldn't be considered an offense. So I think that this amendment is not only very useful, but also necessary to assist those working in the field with people suffering from addictions so that they can properly do their duties. Thank you, Mr. Chair.
Thank you, Monsieur Fortin. We have Mr. Anand Sangari and then Mr. Brock.
Thank you, Mr. Chair. And with this amendment, we are, I think in the spirit of it, we are in agreement. Although this does fall under the defense of innocent possession, so we don't believe it's necessary per se to have it in the legislation, but we are in principle supportive, and therefore however, I do have language that will strengthen the intention put forward by Mr. Fortin that was circulated earlier, and I move that I move the sub-amendment to amend the amendment put forward by Mr. Fortin in BQ6.
Okay, I believe everyone has that. So shall the, Mr. Brock, do you want to comment before this, or do you want to do it after? As there's a sub-amendment now. You're unmute.
Perhaps the sub amendment's not going to change my position on it. To a certain degree, I echo my friend's previous comments with respect to whether this amendment is necessary. We have a concept in criminal law called actus and mens rea. Mens rea is the criminal intent to commit the offense of possession, and with the objective sought by the bloc with this particular amendment and a further sub-amendment by the Liberal Party, in my view, we already have a built-in safety valve in the criminal code, and in my opinion, a built-in defense. I don't think it's necessary. I don't think we need to rewrite, a century worth of jurisprudence. But that's my thoughts. Thank you, Mr. Chair.
Rock. So we will now move to vote on the Liberal sub-amendment to the block amendment number 6. Recorded vote.
Mr. Ananda Sangari. Yes. Madame Brière.
Yes.
Oui.
Mr. Sorbara.
Yes, please.
Mrs. Diab.
Oui, merci.
Mr. Nagvi.
Yes.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Yes. Mr. Fortin. Monsieur Fortin, désolé.
Oui. Oui.
Mr. Garrison.
Yes.
Yes, we have
8. We have 8 in favor, 3 against, carried. Shall block amendment 6 as amended carry? Recorded vote.
Mr. Ananda Sangari.
Yes.
Madame Brière.
Oui.
Mr. Sorbara.
Absolument, oui.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
Oui.
Mr. Garrison.
Yes.
So
11 yeas, 0 nays. The block amendment 6 as amended carries. Shall clause 20 carry? Recorded vote? As amended. Shall clause 20 as amended carry? Recorded vote.
Mr. Ananda Sangari.
Yes.
Madame Brière.
Oui.
Mr. Sorbara.
Yes, please.
Mrs. Diab.
Oui.
Mr. Nagvi. Yes. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison.
Yes.
Yeas 7, 4 nays.
Yeas 7, 4 nays. Clause 20 as amended carries. We have the next is we had a new clause 21 proposed by Green Party Amendment 45. I'm going to rule this inadmissible. And then we have Liberal Amendment 3. It's not been moved. Nobody moves it. I go on to the next one.
I'm going to move the Liberal amendment,
Okay.
Mr. Chair.
Liberal Amendment 3 is moved. However, I'm going to deem it inadmissible as it goes beyond the scope of the bill, so therefore the amendment is inadmissible. Now,
Monsieur le Président, point d'ordre.
Mr. Chair, point of order.
Pourriez-vous juste je m'excuse de
I'm sorry to disrupt the committee. I was reading too many documents all at once. What you said was out of order was a Green Party 45. What did you say for Lib 3? We didn't vote on that, did we? It was also out of order?
correct. It was also out of order. It was beyond the scope.
OK. Merci, Monsieur le Président.
Next, we have Conservative Amendment 15 on page 73 of the package. Mr. Moore, would you like to say anything on this?
That's Amendment 15, Chair. This would require, and this exists in a lot of criminal code legislation, but this would require a review of the legislation on the third anniversary of the day of which it comes into force. So this will allow us as parliamentarians to have an understanding of the impact on our communities with the passage of Bill C5, should it pass.
Thank you, Mr. Moore. Mr. Nansangari.
Mr. Moore, I think that's something that we would support. We would look for a review after the fourth year. On the fourth year.
So, Mr. Nansangari, are you proposing a sub-amendment to that to
delete the word third and to put fourth?
Mr. Fortin, you want to speak to this now, or do you want to speak to it after?
J'allais proposer.
I was going to propose for us to say the 5th anniversary, but I will agree with the 4 years, Mr. Chair.
Thank you, Monsieur Fortin. We shall vote on the Liberal sub-amendment to Conservative Amendment 15.
Mr. Chair?
Yes, Mr. Moore?
I mean, I'm getting a major echo back. I don't know if the rest of you are. I could accept the sub-amendment as a friendly amendment.
Thank you, Mr. Moore. You're probably getting an echo because somebody's mic might have been left on here, and therefore it probably echoed it back. Are you still hearing the echo?
No.
That's good now.
Okay, thank you. So we are going to vote on the Liberals' amendment to Conservative Amendment 15. Recorded vote.
Mr. Anand Nassangari.
Yes.
Madame Brière.
Oui.
Mr. Sorbara.
Yes, please.
Mrs. Diab.
Yes.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
Sub-amendment, yes. Yes.
Yes. Okay. Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
Oui.
Mr. Garrison.
Yes.
So 10 yeas, 1 nay.
That's 10 yeas, 1 nay. The amendment, the sub-amendment to Conservative Amendment 15 carries. Shall Conservative motion, Conservative Amendment 15 as amended carry? Recorded vote.
Mr. Anand Nassangari.
Yes.
Madame Brière.
Yes.
Mr. Sorbara.
Yes, please.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin,
Oui.
Mr. Garrison,
Yes.
11-0.
11 yeas, 0 nays. It is carried. Shall the title carry? Can we do this one on division, or do we want a recorded vote on this too?
On
Carries.
division.
Okay. on-
Carry without division.
Carry. Yeah. Okay, thank you. Shall the bill as amended carry? On division.
Recorded vote,
vote.
Mr. Ananda Sangari,
Yes.
Madame Brière,
Oui.
Mr. Sobara,
Yes, with 2 thumbs up.
Mrs. Diab,
Yes.
Mr. Nagvi, Mr. Brock, Mr. Brock,
No, thank you.
Mr. Cooper,
No.
Mr. Moore,
No.
Mr. Morrison, Morrison,
No.
Monsieur Fortin,
Moi, Monsieur le Président, je
For me, Mr. Chair, I would vote yes to diversion, but no to the abolition of minimum sentences. So I'll have to vote no, since we did not agree to separate the bill. Mr. Garrison,
Mr. Yeah,
Yeah. Yes.
so 6 yeas.
So 6 yeas, 5 nays. The bill carries as amended. Shall the chair report the bill as amended to the House? Recorded
On
vote?
division.
On division, okay. Carried. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? On division?
On division.
Carried. All right, thank you very much to all the committee members, and I want to especially thank the witnesses who have been very patient and stayed with us for all this time. All the staff in the room, I want to really thank you, and those staff that have already changed and have gone, I want to really thank you, the clerk's office, the legislative clerks, and everyone supporting them behind the scenes. And so, and all the staff on both sides, I want to thank you all once again, for making this meeting very efficient. Thank you very much, and we adjourn.